Canada's leading independent legal publisher. Welcome to the Lawyer's Lounge, a criminal law-focused podcast. Wherever you are, whenever you are, the Lawyer's Lounge is always open. Come on in.
Hey, Lisa told me to tell you this. We are not your lawyer. The Lawyer's Lounge is an entertainment podcast and is not legal advice.
Hey everyone, great episode today. We've got Nader Hassan talking about the Sharma decision out of the Ontario Court of Appeal and its implications on mandatory minimum sentences and the availability of conditional sentences. We have a special guest, Sana Helwani, a civil litigator, IP specialist, who has logged, we believe, the most amount of time in Zoom litigation since the pandemic began. She'll share her insights and tips on how to effectively advocate virtually. And Lisa and I will share our own hacks and insights based on our own experiences litigating in the criminal arena by Zoom. We hope you like the episode.
Okay, well, we're very lucky today to be joined by Nader Hassan from Stockwoods. Nader recently was lead counsel along with Steve Aylward in a fantastic decision from the Ontario Court of Appeal, Sharma, and we're lucky to have him here to talk to us today about that. For those of you that don't know Nader, the very few of you, he is a partner at Stockwoods in Toronto who does criminal, regulatory, and constitutional law, does trial and appellate level work, and is a frequent flyer at the Supreme Court of Canada, is an excellent lawyer in Toronto, and I think is a fantastic constitutional litigator. So we're very lucky to have Nader here with us today.
Thanks for having me.
So Nader, can you just walk us through a brief factual précis of the Sharma case so that our listeners kind of know what it's about?
Yeah, of course. My client, Shan Sharma, she endured what the trial judge described as the classic constellation of Gladue factors growing up. She had a difficult childhood. She's biracial, of Indigenous ancestry, Ojibwe ancestry to be more specific, and she's a member of the Saugeen First Nation. Growing up at a pretty young age, her father was deported to Trinidad after being arrested on a charge of murder. And from that time onward, she lived with her grandmother and her mother and her other siblings. She did have a difficult childhood and ended up running away at a very young age and was involved in sex work at a very young age. Many challenges she faced during her teenage years, but she never got in trouble with the law and didn't have a criminal record, despite the various difficulties she faced. She ended up having her daughter at the age of 17 and was living with her daughter and doing well on her own despite her limited means. But then when she was around 19 years old, she reached a point where she was having trouble making ends meet, and she was 2 months behind on rent, and she was facing eviction. And her then boyfriend at the time said, okay, I see you're having some trouble making ends meet. Here's a way for you to make a lot of money. You go to Suriname, pick up this suitcase for me and bring it back, and you'll be paid for that work. And she knew what she was getting into and brought the suitcase back, which of course contained cocaine. She was apprehended at Pearson Airport and immediately made a full-throated confession and pled guilty at a very early opportunity. Here's the problem. The problem she faced was that she was in so many ways a very sympathetic offender for a drug importation offense. She's someone with no criminal record. She was very young at the time. She was a single mother. She faced a lot of systemic discrimination throughout her life. And then there were, in addition to that, the Gladue sentencing principles that were supposed to help her in a situation precisely like this. But there was a mandatory minimum, which counsel challenged in the court below, and which Justice Casey Hill struck down on Section 12. But then the other problem was that there was this Safe Streets and Communities Act that was passed during the Harper years, which made it impossible, it made it prohibited to get a conditional sentence for drug importation offenses. And so Ms. Sharma at the trial level challenged these limitations on the availability of conditional sentences on Section 15 and Section 7 grounds, and Justice Hill rejected that argument. So that's what the appeal was about. Our mandate here was to argue before the Court of Appeal that Justice Hill, despite his wisdom, erred in that respect, and in fact these conditional sentence limitations under the Safe Streets and Communities Act were constitutionally infirm under Section 7 and Section 15 of the Charter.
Section 15 is not that commonly used in the criminal context. Some might say underutilized, some say that's appropriate. What I know that it was advanced the first time at trial, but what motivated you to pursue striking down this section under Section 15 in particular?
Yeah, Lisa, you make a good point. I mean, there, like you, I had the sense that for a long time, Section 15 had sort of laid dormant when it came to the criminal law. There had been various challenges over the years to mandatory minimum laws as well on Section 15 grounds, and they didn't seem to go anywhere. And what I think we were finding, though, in cases like Noor, in cases like Safarzadeh, Markali, is that even though the court isn't relying on Section 15 to strike down legislation, they're doing it under Section 7 of the Charter, or they're doing it under Section 12 of the Charter. Oftentimes they are incorporating equality law principles to inform the principles of fundamental justice, or to inform the Section 12 analysis. I mean, our reasonable hypotheticals under Section 12 invariably involve a person who is from a equity-seeking group. So it's not as if Section 15 ideas have been dead. It's just that provision of the Charter has lain dormant as a matter of criminal law constitutional challenges. But just because it's been laid dormant for so long, it doesn't mean that's right. And so, this case was very much about, in terms of some other goals that counsel and interveners had in a case like this one, it was in large part to try to resurrect Section 15 as a standalone means by which to advance equality arguments in criminal law constitutional challenges. And of course, there had been some of those recent cases at the Supreme Court of Canada, like Tapetat, which the Court of Appeal relied on here, and the Quebec pay equity cases that seemed to really move the needle on the Section 15 framework and analysis, that I think led some of us to think, hey, maybe now is the time to try and take another hard look at seeing if we can make Section 15 work in these criminal law constitutional challenges.
Right. I mean, there are lots of bright lights in this decision, so it's hard to pick what the highlights are. But one thing that I thought that might have broad application was Justice Feldman disagreeing with Justice Hill about what kind of record is necessary to substantiate a Section 15 argument. And I mean, I don't know if you want to talk a little bit about that, but I was really happy to see her taking the position she did about what is necessary and what's not necessary to be able to demonstrate, a claim.
Yeah, I mean, I think the way that Justice Hill had conceived of, what you needed the empirical record to show, I think is inconsistent with the way the criminal law, the law in Section 15 has really been going. I think on Justice Feldman's reasoning, if this law, the Safe Streets and Communities Act, undermined substantive equality for just one person, that would be enough in terms of an evidentiary record. Whereas Justice Hill seemed to take the view that in order to make out a Section 15 claim, you'd have to show that Indigenous women were disproportionately disproportionately more likely to be charged with a drug importing offense, and therefore disproportionately more likely to be harmed by dint of this law as compared to the rest of the population. And that's not what Section 15 requires, and certainly not under the law of Section 15 as it exists today. And I think Justice Feldman makes that very clear. I mean, all that being said, though, I think the record here was pretty good, and I think that was what differentiated this case from some of the other Section 15 challenges. There was quite a wealth of social science expert evidence that was led in the court below. Dr. Murdoka testified at length and provided a very lengthy expert report that described the impact that the unavailability of conditional sentences was having on Indigenous women. And indeed, there were, as part of that evidence, there were case studies that were brought to the attention of the court in which it was clear, based on one particular study, that in the 31 cases where Indigenous women had been given conditional sentences, if though the Safe Streets and Communities Act had been in effect at that time that they went to sentencing, 29 of those 31 cases would not have received conditional sentences. So there was compelling evidence on the record in terms of disparate and disproportionate impacts. But I thought you're right. It was refreshing to see Justice Feldman conclude that you don't actually need that kind of an evidentiary record when what you're seeking to do is to explain that the law that's been impugned undermines a remedial framework that is necessary to undo systemic discrimination. And that's really the heart of the Section 15 analysis.
Now, Nader, the attention around Section 15 has been exciting, and observers and lawyers are very interested in the 15 analysis. But there's also some exciting developments on the 7. Can you talk to us about the Section 7 analysis here?
Yeah, absolutely. Ultimately, the court concluded that the impugned provisions also violated Section 7 of the Charter on grounds that these laws were overbroad, meaning that there was a disconnect between the